for the state is strong. That's how I understand your role.
I hear you.
Okay. And then what I've also heard from your testimony, which if you would like to correct, is that all the grounds are identical in respect of all the applicants that you opposed.
Of course.
Is that how your testimony is? That in respect of all the applicants, the grounds for opposition are identical?
Of course.
Okay. But you do agree that each and every one of them has their own charges. Is that correct?
That's correct.
Right. Okay, Mr. Inambao, let's quickly understand what your role was at Standard Bank.
I was the manager forensic investigations.
Okay. Then what did your duties at a high level involve as a manager of forensic investigations at Standard Bank?
It involved the investigations of the financial fraud risks that were happening at the time in Standard Bank, both from the internal perspective and as well as the customer perspective, as well as to address, to put in some remedies to ensure that those loopholes or the gaps were closed so that the bank was protected from fraud risks.
Okay. Would I be correct that you would also then be exposed to dealing with financial transactions?
That's correct.
Okay. That in that role, you were also exposed to dealing with how to interpret financial statements?
The financial statements, when you say financial statements.
Not bank accounts, sir.
Yes.
Financial statements. I'm very careful with my words.
To some extent, yes, but more so it was based on the transactions.
Yes,
because,
we'll get to the transactions. Yeah. Okay. Would it also then entail exposure to looking at bank statements?
That's correct.
Okay. When you do your investigations in that role?
That's correct.
Okay. Furthermore, were you also exposed to understanding how online banking works?
That's right.
Okay. Would I be correct that in that role, you were also exposed to investigating, for example, disputed transactions by clients against the bank?
That's correct.
Okay. That would mean then, sir, that I would be correct if I say you are familiar with how online access banking would work typically?
Of course.
Okay. And that you understand that when a person is a signatory to a bank account, it does not mean that you have access as in the online banking access details. It's two different things, am I correct?
Yes, just repeat the question.
Okay. Let's break it down. A signatory to the bank account, before he or she can transact online on that bank account, requires online access banking details. Am I correct, sir?
You are correct.
Okay. And those banking details are typically provided by the banking institution where the bank account is held.
You are right.
Okay. And that then it's not automatic that a signatory to a bank account has access to online banking without those details, isn't it?
Yes, without the details, you can't have. But in order for one to acquire those details, that person requires the authorization from the account holder.
That's correct, sir. You just answered my subsequent question. That for you to get the online banking details, you need to be a signatory or you should be authorized by the holder of the bank account.
Of course.
Okay. All right. That's good. You also, in that role, I'm assuming, and you need to correct me, in that role you also learned more knowledge about how hire purchase agreements work. Am I correct?
That's correct.
Okay. And that in a hire purchase agreement, a deal, for example, the client is the applicant, isn't it?
Yes.
And once the applicant's application is approved, there are installments that must be paid on regular intervals by that person, isn't it?
That's right.
Okay. However, ownership of a vehicle or an item that is the subject of a hire purchase agreement would only pass upon the final payment in terms of that agreement, correct?
That's correct.
Okay.
However, in terms specifically when it comes to vehicles, vehicles are registered on the client's name, meaning the ownership in terms of the registration with NETIS can still change. We list that asset is still under hire purchase without the knowledge of the financial institution.
To assist you, sir, I was referring to ownership in law. I'm not talking about what people will do when they want to do whatever, but ownership of a vehicle or an item that is subject to a hire
Sure.
purchase agreement only passes upon the payment of the final installment.
Sure.
Okay. The registration at NATES is a different issue, sir. We agree?
Yeah, we agree.
Okay. That means then that this vehicle, on your thesis, the vehicle that you are looking for or that you say you are searching for still belongs to the bank who financed it. Am I correct?
That's correct.
Okay. Were you able to check who was paying for the installments of that vehicle, sir, in your investigation?
Yes, we were able to check.
Okay. And who would that be, sir?
That person is not part of the applicants here, and I'm not sure whether I should disclose that.
Sir, you should answer the question. I won't put an irrelevant question to you. That I can assure you.
Which vehicle are you talking about in the first place?
In these proceedings, we've only spoken about one vehicle. And you know which one, sir. So please answer the question.
No,
Mr.
but at
Nambao.
least they give me guidance. I've spoken about many vehicles.
Mr. Nambao, the vehicle that you say Mr. Mulunga accepted, you know that's the vehicle we're discussing. Who was paying for the installments of that vehicle, sir? Which company?
That was not being paid by a company. It was paid by an individual. But at this point in time, I want to say we will not disclose the name because we are still investigating.
Okay.
But we know who is paying, from whose account the money is coming from.
Your Worship, the witness should be directed to answer the question at this point of the proceedings.
Yes, he has responded that he is not able to disclose at this point.
Your Worship, when a witness gives that answer, that's not the end of it. A witness of this nature, if he says I can't disclose, he must say why he cannot disclose.
That is why you are there. You can make follow-up questions if you want to.
Not
Yes.
a problem.
Yes, but the court cannot tell him disclose.
I did not say disclose, I said answer the question.
But you are saying that you did not answer the question, so you want him to disclose.
It's fine, Your Worship. Let's-
Only one speaker at a time. Yes, please. Yes, he has responded. You can always make follow-up
As
questions.
it
Yes.
pleases the court.
Yes.
Mr. Inamba, what is the reason you cannot disclose who's paying for the installments of the vehicle?
I told you the person who's paying for the installment of the vehicle is not one of the applicants.
Okay. So would I also accept that that person is not in court today?
That's right.
Okay, that's fine. We can leave it. That is fair enough. All right, let's look at the investigation team composition. You indicated that you were the lead investigator in the matter.
That's correct.
Without mentioning your team member's name, how many are you that are investigating this matter?
About 4.
Okay, about 4. Would you be able to tell us if your team comprises of junior members or senior investigators, experienced such as yourself? Or is it a good mix?
Yeah, it's a good mix.
Okay. So in that team of yours, how many of those team members are trained in investigations involving or premised on contractual agreements? Let me repeat the question, sir. How
hear.
many of your team members are trained in investigations involving or premised on contractual agreements?
We are trained in this regards to investigate fraud, specifically corruption and money laundering. So The contractual obligation is normally a civil issue which is sorted there outside. And we know that matters can run parallel. Where there's an element of fraud, corruption, money laundering, that's what comes to us. That's what we investigate.
Mr. Inambao, how many of your team members are trained in investigations involving or premised on contractual agreements specifically,
No.
sir?
We
One
don't
or
have
two?
training targeted for contractual obligations.
Okay, thank you. And then the next question, sir, is a different one. How many of your team members is experienced? The first one I said trained. How many of your team members is experienced in investigations that are premised or involve contractual agreements?
My answer is the same as previous.
Okay. You agree that this matter involves quite a number of contractual agreements, is that so?
That's correct.
And because of your answer that you gave me about the composition and the training and exposure, I'm going to ask the next questions in the following manner. I'm going to make a proposition to you. If you are able to accept it, please say so. If you are not able to, you are also welcome to say so. Okay. Mr. Inambao, a preamble of an agreement is usually a preliminary section that sets out the context of and explains the background of such an agreement. I can repeat it. A preamble of an agreement is usually a preliminary section that sets out the context of and explains the background of the agreement.
I feel like I'm in an examination. That's what it is.
Okay, thank you, sir. I can also, just to be complete, refer you to page 51 of the exhibit D1 and give you an example of what a preamble is of an agreement. If you go to page, do you have the right exhibit, or may I? Exhibit D1, please. Thank you. Okay.
Which page?
The agreement is the asset purchase agreement. It starts at page 51, but an example of a preamble is on page 52, sir. Okay, that would be an example at the beginning. Okay, so
Where are you concerned?
if you look at page 51, all those sentences that starts with whereas, my lord.
52.
52, sorry, 52. Thank you, sir. All those sentences that starts with whereas, that is part of what we call a preamble, and then the agreement is, the terms are set out thereafter. So typically a preamble.
Counsel, do you have any comment? You must just allow them to comment.
Sorry, he actually nodded, and I should have corrected him
Yeah.
to verbalize it.
Yes, Your Worship, I see I'm on the page.
Okay, thank you, sir. And typically, a preamble would outline, firstly, the purpose of an agreement, the parties that are involved in the agreement, and then there are reasons for entering the agreement. Would you agree with that proposition?
Yes, I would agree.
Okay. Furthermore, sir, a variation clause in an agreement usually dictates that any changes to a written agreement must be made in writing and signed by both parties in order for such a change to be valid. It's also known as a non-variation clause. Would you accept that proposition?
That's right.
Okay. Now, while we are still at that agreement, All right, this specific one doesn't have, but it's fine if you accept the proposition. Another proposition I want to make to you, Mr. Inambao, before we move on to contentious matters, is that the Namibian fuel industry is a specialist industry and it's regulated by law. Do you accept that proposition?
Yes, I do.
Okay. Now, in line with my previous questions, which one of your team members in the investigation team is trained in investigating matters in a specialist fuel industry?
We were not investigating the fuel. We were investigating the actions which led to the supply of fuel. In this regards, the conduct of the staff member in authorizing the supply of fuel. That's what we were investigating.
Mr. Inambao, which one of your team members in your investigation team is trained in investigating cases in the fuel industry?
No one.
Okay. And then the follow-up question would be, which one of your team members is experienced in investigating cases in the fuel industry?
It's the same.
Okay. Another proposition I wish to make, and I want to invite you to agree with me, is that your investigations, since they are not yet completed, the picture could look the same or it could look different at the end of your investigations. Is that correct?
Just hold on before you respond. Do you understand the question?
Maybe that proposition can be repeated again so that we can provide an answer.
Okay. Mr. Inambao, you've indicated that your investigations, although they are at an advanced stage, sir, they are not yet completed. So the proposition I'm making to you is that at the end or at the completion of your investigation, the picture in this whole case could either look the same or it could be different. Is that a proposition you are willing to accept?
Not entirely correct. I would say that the proposition could almost look the same. Because,
you mean the picture?
Yes, the picture could almost look the same.
Mm-hmm.
And I'm saying so because as far as the evidence that we have gathered, the more evidence that we have gathered, we were able to do a bit of financial analysis to connect the subjects to understand what happened in this regard.
All right. That answer you give me proposes that you are saying you don't expect the picture to change considerably. Is that fair?
Yeah.
Okay. Which then supports your proposition that your investigations are at an advanced stage.
That's right.
Okay. I want to, before we move to that, Mr. Inambao, I don't have the...
Here you said Mrs. Namcor.
Mr. Sorry, sir. Mr. Inambao, I don't have the act that gives you your powers, but I want to make the proposition to you, while my colleague gets it, that you are tasked with investigating allegations. If you go to D2, if we need to be precise, page 34, D2. Mr. Namanje's bundle of legislation. The act starts at page 34. I wish to invite the court to to please have regard to section 3 of that act at page 37.
Are you there?
I'm there, Your Worship.
Okay. Mr. Inambao, the
Just a
functions.
minute. Here, Lumba is located. We can proceed.
Okay. As it pleases the court, Mr. Inambao, the functions of the commissioner at section 3.
That's right.
Those functions, I want to make the proposition to you that if you look at those functions at all times, they refer to allegations in relation to the practices you must investigate. Is that correct?
That's correct.
Okay. If you look at subsection 3A, it says the functions of the commissions are to receive or initiate and investigate allegations of corrupt practices. Is that correct?
That's correct.
3 subsection B says the further functions of the commissions are to consider whether investigations is needed in relation to an allegation, and if so, whether the investigation must be carried out by the commission or whether the matter should be referred to any other appropriate authority for investigation. And I can read all of them. They refer to our allegations. Is that correct?
That's right.
Okay. So when you investigate the allegations, you are required then to send them to appropriate authority, being the prosecuting authority, to prosecute those matters. Is that correct?
That's right.
And the ultimate aim would then be to have the court test the evidence that you would have obtained in your investigations. Is that correct?
That's right.
Okay. And I want to propose to you that the use of the word allegations in that section, sir, takes into account that accused persons, when they come to court, are presumed innocent until they are convicted by a competent court of law, not by ACC.
At no point I said the accused persons are guilty. I
Okay.
have always maintained that we investigated the allegations and the evidence suggested these offenses were committed. So no point did we say the accused persons are guilty.
Okay. The reason why I put that proposition to you, sir, and I want to give you a chance, because when I argue, you won't be here. You've used words such as perpetrators to describe these accused persons. Is that not correct?
I use the word.
Perpetrators in these proceedings.
I use the word when the offenses were perpetrated.
Okay. So your answer is saying that I'm wrong. I did not hear you use the word perpetrators. Is that what you're saying?
Yes, perpetrated and committed, they are almost synonyms.
Sir, are you saying you didn't call these accused persons perpetrators?
I call them accused persons, I call them applicants.
Okay.
But I did say when the offenses were perpetrated.
Okay. And the further question that I have, which I must also put to you because when I make the submissions you might not be here, is that in your testimony you have at all times indicated to the court that you in your mind have decided that the crimes have been committed by these accused persons.
Not entirely correct. I said evidence.
Yes.
Evidence has indicated offenses were committed and they were committed by the accused persons because of the link. Hence the accused persons was, apprehended and brought to court.
Okay. So that means your position is that the evidence you have currently suggests that the crimes have been committed.
That's right.
Okay. That would be the correct position. Okay. Let's move then to the asset purchase agreement, sir. That's the bundle D1. And that would be page 55, sir, at paragraph 3.
Just law.
As it pleases the court, Your Worship.
What page?
Page 55, paragraph 3. are you there?
Yes.
I'm
Mr.
there.
Nambao?
I'm there.
Mr. Basson? Okay, thank you. Mr. Nambao, that provision, I'm not going to ask you to read it. I know you've read it a few times. This is the proposition I'm making to you. That provision, in summary, at 3.1, 3.1, yes, 3.1, the heading at 3 is utilization of Namcor trading assets for storage of petroleum products. 3.1 specifically, after the transfer, authorizes then Enercon to utilize and store only petroleum products purchased from Namcor Trading for the duration of the supply agreement between Enercon and the Ministry of Defense. Do you agree that that's what is written there?
Yes, that's what is written there.
Okay. So the next thing I want to propose to you is that when you gave evidence in chief and also repeatedly in cross-examination, you informed the court that despite the asset having been purchased by Enercon, at the different basis, business continued by Namcor. Let me repeat that. Despite the assets being purchased from Enercon by Namcor, the business continued as usual. Enercon proceeded to supply the Ministry of Defense with fuel. I want to propose to you that it is in accordance with that agreement, with that specific section. And I believe it's a fair proposition to make to you.
I don't think that is a fair proposition. And I remember when I testified in chief, in the examination in chief, and this was a point where I said, which begged the question as to why Namcor Trading would in the first place buy the same assets only to allow Enercon to continue using them.
Okay.
So,
all right. So that question has been answered. And I want to make that proposition to you as well, because it's a question you keep asking. We all know why. Namcor wanted that strategic client. That it's all over the documents. What I'm proposing to you is a different proposition, that it's continuing as business as usual, in your words, in accordance with the clause 3.1, which says from now on, now that the assets belong to Namcor Trading, Enercon, you may use them, but you are only allowed to service the Ministry of Defense, and you may only buy petroleum products from Namcor. Then you continue as business as usual.
you know, at the same time, Enercon had an agreement which was also still in force with the Ministry of Defense, where these very assets, upon which these very assets were as a result thereof constructed or placed on those sites.
I still want you to answer my question. That you told is usual, it's really useful. We'll get there with the duration and how you come to encumber. But I want to propose to you that the business as usual continuing on is in line with clause 3.1.
Yes, and we are saying that, all these conditions which are here, including this one, these were just conditions which were inserted there because there was no physical changes or there was no material changes which happened. Enercon continued operating business as usual, the way they operated before and after the contract.
Yes.
So, and hence the evidence suggests this was simply a document which was created inclusive of this condition you are reading. It was simply put there to ensure that when Enercon uses the assets, it looks legitimate.
Okay.
So, and we are not changing our position that, this document is an instrument which was simply used to facilitate the payment of the money from Namcor Trading.
Mr. Nambao, I'm not going to repeat the question 4 times. I was doing it for your benefit. We leave it at that. That's your final answer.
That's my final answer.
Right. Mr. Nambao, do you know what is a usofra?
What is there?
Usofra.
No.
Okay. Also, Mr. Nambao, when you are testifying here, your testimony is based on what you have discovered in your investigations. Am I correct?
That's
because
right.
you were not there, right?
That's correct.
Okay.
So it's determined or based on the evidence that was collected.
Okay. Before we call it evidence, let's unpack it. You are testifying about documents that you came across in your investigations. Am I correct?
That's right.
You are testifying about statements you obtained from witnesses. Am I correct?
That's correct.
You are also testifying based on bank statements which have been produced here. Am I correct?
That's correct.
As well as, I suppose, invoices, purchase orders, documents.
That's correct.
Okay. That's what you mean when you say evidence. Is that correct?
That's right.
Okay. How many invoices did you produce in these proceedings in respect of fuel purchase? Is it 1, 2, 3? How many?
Your Worship, it has not been my duty to disclose any part of the docket or the evidence to the defense.
Okay.
And I never testified to that effect. I said I collected the evidence. Yes. Evidence was presented to prosecution.
Okay.
And whatever that was presented to you is between you and the prosecution.
Please don't you me, sir. Please don't address me like that. Your Worship, if the witness can be directed to not address me directly.
Just refer to whatever was disclosed to the councils of record is between the councils and the state.
Okay. Mr. Inambao, let's keep this respectful, please. My question was not about disclosure, so I'm going to give you another chance. What evidence did you produce in these proceedings pertaining to invoices for fuel purchased?
I've answered the question already. As far as the investigations is concerned, yes, we were able to collect invoices that we reconciled to the amount of 274 million in terms of the fuel, and as well as the invoices for the purchase of the assets. I believe the invoice for the purchase of the asset was part of the asset purchase agreement. Okay, so I'm not sure whether it's there or not.
You are referring to the invoice for the purchase of an asset?
Yes.
I'm referring to invoices pertaining to purchase on supply of fuel. Did you produce any in these proceedings?
It was not my duty to produce. I was here. Evidence has been given to me upon which I was cross-examined. Yes. So I didn't produce.
Okay.
But I'm sure the state had, the evidence.
That last part you didn't produce. That's the only answer I required. Okay. So I'll move on. There's also this amount that you keep mentioning in excess of 200 million.
Can you be specific?
Yes.
You are saying in excess of 200 million. Do you have a specific amount or you don't have a specific amount?
Sorry, don't worry. Mr. Inambao?
I'm just asking whether, if you don't have, you simply indicate.
No, Your Worship. Yeah. It's okay. I'll give you an amount, Your Worship. I'm here at your service.
Because it appears that you are not comfortable to respond. I'm just asking, the answer says in excess. Do we have a specific amount or we don't have a specific amount?
Your Worship, I'll give you the amount. I won't debate the issue.
Okay.
Yes. If they may accuse. Okay. Mr. Inambao, if you go to page 28
Of which bundle?
Of bundle D2, which contains the charges, If we start at 27, the amount I'm referring to in this specific instance, you will find at count 60, in respect of Mr. Leon Nandawa Stefan as my client, applicant 7, there is supposed to be a 238 million.
That is at page 7.
27, 27. If you look at count 61, there's fuel supply in respect of Irongo Petroleum and fraud at count 60. The amount is 238 million.
What is at count 61 or count 60?
My Lord, Your Worship, we have indicated already in our affidavit that 10 is left out in terms of count 60. The correct amount is, however, repeated in count 61 in the allegation.
Council, I'm just trying to follow. You said at page 27.
Correct.
Yes, so I'm asking at page 27, are you talking about count 60?
Both,
or
my
count
Lord.
61?
Both.
Both.
Yes.
Okay.
Yes. Okay. So let's come back to the question. Sorry for that detour. I have to assist the court. That's one of the amounts you have been referring to in your testimony. Is that correct?
That's correct.
Okay. Mr. Inambao, you haven't, in this proceedings, I don't know if it's in your consultations or in your investigations, but in this proceedings, you haven't produced evidence to indicate how many liters quantity of fuel make up this value of 238 million. You have not yet done so in these proceedings.
Your Worship, although we haven't specified the liters in the charges or in the proceedings, it was much better for us to work on the figures because each of the invoices were reconciled. Each of the invoice has the amount of liters that met or which determined the value at the time when the specific invoice was issued or when the supply was done. So, and during the trial, Your Worship, these invoices would be presented in evidence. They would indicate the liters, they would indicate the amounts.
Yes, but here they have not. You agree with me? You have not produced those.
I haven't been cross-examined on them.
Okay.
Not because we didn't produce them. As far as the investigations is concerned, we were able to gather them. In fact, when I testified in the examination in chief, I indicated that when the complaint was initially reported, it was indicated the combined amount was 277 million.
Okay.
But when we did the reconciliation, after having collected now the invoices, the amount came down to 274 million. So as far as the investigations is concerned, we have the invoices.
You have the invoices, sir. You have not produced them in these proceedings.
It was not my duty to choose or to select which documents or which evidence to provide to the defense.
You have not produced them, sir.
It was not my duty.
Okay. And because you have not produced them, this court must rely on your say-so, solely on what you testify.
Of
Is
course.
that not so?
Of course.
Okay. Furthermore, if you look at, for example, charge number 61 in respect of my client, there's a period of December 2022 to May 2023, and then there's that big amount of 238 million. We've already dealt with the quantity. You have also in this proceedings not produced or adduced evidence to this court as to how much of that amount was actually paid, whether it's 0, whether it's 10 million or 100 million. You haven't.
Your Worship, in my examination in chief, I said very little payment was done.
Okay.
But the most important aspect was that the fact that Erongo Petroleum only had a credit limit of 10 million, which meant that fuel was supplied in excess, at least to the value, $228 million more.
We'll get to the credit limit, sir. My question is a very simple one. Have you produced any evidence in these proceedings, not a trial, not what's in your docket? Have you produced any evidence in these proceedings which indicates the payments that Erongo Petroleum had made towards the fuel that was supplied between December 2022 and May 2023?
The concern was the amount of fuel that Erongo did not pay for.
Okay.
And that was the amount that was approved, the amount of fuel that was approved above the credit limit.
Okay. I've repeated that twice now for you. I'll make the necessary argument when it comes. I was just doing it for your benefit, in case you didn't understand. Okay.
I understand you very well.
All right.
And I've been saying all along,
Yes.
it was not my duty to choose which documents to give you.
Okay.
So,
Mr. Inambao, it's not me. Again, it's not documents to give to me. And I'm also not asking you about disclosure. So let's make it also clear.
but you are making it seem as if it was my duty
No.
to provide the evidence
Okay,
to the defense.
let me also disabuse you of that notion. I know it's not your duty. Nobody here said it's your duty. We are talking about you as a witness in these proceedings. So let's get rid of that one. I'm not saying it's your duty.
But you keep asking.
I have to ask.
Yes, he's asking, just keep your answer and then we move on.
Okay. All right. The other thing that we must also unpack and make sure that we assist this court. These charges that are preferred against the accused persons, you term them as preliminary charges. These are the charges that you are saying are serious. Am I correct?
Of course they are serious.
Okay. Furthermore, these charges that you term as preliminary charges, these are the same charges that you are saying on which the state has a strong case. Am I correct?
That's correct.
Okay. So whether they change later, they are amended, they are fixed, that will be an issue we will deal with in trial. But today, these are the charges as they are. Am I correct?
That's correct.
All right. Right. My colleague, Mr. Casper, took you through the issue of the outstanding investigations. This is a very important question or aspect of your testimony, sir, and I feel that you must be given a chance to deal with it. So the next questions I'm going to ask you about that. Your objection to bail, is it until your investigations are concluded, or you want the applicants to remain in custody until the trial is finalized? Which one is it?
Well, there are a number of reasons as to why the state has called me to come and object to bail. It was not only the reason of the investigations that was outstanding. It was inclusive of other factors.
So I'll unpack those. Mine
Yes.
is-
No, and I'm telling you, I can't collectively, I can't give you one answer on one ground. It's a collective answer on all the grounds. So in this regard, one of them was investigations not yet finalized. The risk of interference with witnesses and investigations, the risk of abscondments, and the seriousness of the offense. And I don't think those risks will shy away because the investigations is completed.
I'm going to repeat my question, sir. Your objection to bail, is it until The investigations are completed, sir, or is it your opposition that the accused persons remain in custody until the trial is finalized? It's important for the court, not for me.
I've given my answer.
All right. I've repeated the question. That would be your answer. Mr. Inambao, these type of investigations, in your experience, typically a prosecutor general's decision would be required, isn't it?
That's correct.
Okay. And then I want to propose to you that this type of matter or this specific matter is likely to be tried in the High Court. Am I correct?
That's correct.
Okay. So that's two things. First, investigations will have to be completed before the prosecutor general's decision is made. Am I correct?
You're right.
Okay. Thereafter the prosecutor general's decision is made, the matter would be transferred to the correct court. Is that correct?
That's correct.
And that court is likely to be the High Court of Namibia. Am I correct?
You're right.
Okay. And then when we are in that court, the trial court would then be seized not only with determining the guilt or not guilt, but there's also sometimes interlocutory applications like disclosure, etc., etc. You agree?
Of course.
Okay. So after I've now laid that foundation with you, I want to propose to you that excluding these proceedings, this matter is likely to go to trial only after 10 months at the very least.
Just slow down. Sir, do you have an answer?
Your Worship, I cannot commit to the time frame that was given by the council. All I can tell the court is that we will ensure to finalize the investigations. The PG's office would be responsible for making the decision. I'm not in control of that time. And when the matter is referred to the High Court, I'm also not in control of that time.
Okay. Mr. Inambao, is this matter likely to go to trial next week in August of 2025?
No.
Okay. So we've taken out August 2025. I have to do this because you don't want to give an estimate. November 2025? Is it likely to go to trial?
There is no way. We have just indicated in the evidence in chief that there are still issues that we still need to finalize. Most likely, there's still suspects also that we still need to have appear.
Okay.
And there's no way we can be talking about August, which we are already. I mean, this is August already.
I'm now in September,
Yes.
sir.
Or September.
Okay. Then I will skip October and November and go to December 2025. Is this matter likely to go to trial in December of 2025, sir?
I don't think so.
Okay. Then let's go to March of 2026. Is this matter likely to go to trial?
I cannot confirm that.
Okay. That's where you stop confirming. At December of 2025.
Yes.
Okay. Then the next proposition I want to make to you, and I believe it's a fair one, in this country, in this jurisdiction, an accused person cannot be kept in detention as a form of anticipatory punishment. Do you agree with me?
And nobody is saying it's a punishment. All we are saying is the offense or the offenses are serious. The likelihood of interference with investigations, especially considering the complexities that are involved in money laundering, it makes it high. We have one of our suspects is currently not there. So possibility of evading justice is there. And that's all we are saying. We are not punishing anyone. We are saying this is a case, it's serious, And these are the reasons. And it's the duty of the court to determine as to whether what we are telling the court it's valid or not.
Okay, sir, I haven't accused you of punishing anyone. Let me repeat my statement to you. The proposition I wish to make to you, which I believe is a fair proposition, is that in Namibia, in this jurisdiction, an accused person cannot be kept in custody. Whether I'm the accused person or you are the accused person, cannot be kept in custody as a form of anticipatory punishment. Do you agree with that proposition or not?
I'm not going to agree or disagree, but I've given you my answer already.
Okay, so I've repeated the question for you. I will make the necessary arguments. Okay. These proceedings, sir, are bail proceedings. This court is not seized with determining the guilt of these persons. Do you agree with me?
I mean, we are here because of bail. So it's not to determine whether the accused persons are guilty, it's to see if they can go for bail or not.
Okay, very good. Before Mrs. Elindi Lydia, Your Worship, I'm sorry I forgot what applicant number she is. Is it 3? Thank you. Before the third applicant was granted bail by this honorable court, did you have an objection to bail?
I believe that is why she was in custody.
Okay, thank you. However, the court deemed her a candidate worthy to be admitted to bail, and that's why she's on bail. Am I correct?
You are correct.
Okay. Okay. When we are dealing with bail, the issue of the seriousness of offenses and the likelihood of attracting custodial sentences if convicted is very important. Do you agree with me?
That's correct.
Okay. So I want to invite you, sir, to please return to Exhibit D2 because you didn't do that part in your evidence. I want to give you an opportunity. If you go to Exhibit D2 at page 27, count 60.
Okay, give me a second.
Take your time.
This one is trying to get loose. So. You said which page?
Exhibit D2, page 27.
Oh, I'm there already.
Okay,
I'm
thank
there.
you. So what is the penalty clause for that charge at count 60? What's the likely punishment if my client is found guilty by some miracle?
The Anti-Corruption Act provides a fine of 500,000 or 25 years imprisonment, if I'm not mistaken.
You can just speak up, sir, and then if you would like to look at the act.
Let me verify it from
Yes.
the act. Penalties provided in the act.
In your worship, through you, I see that the witness is on this side. I'm not sure if the recorder will pick him up. I just want to request him to please stay close to the mic so that our
It's because of the paper.
I understand, sir. It's just a request so that the transcript is useful. So, 34 penalty. It's fine.
Yes.
Okay.
500,000 or 25 years imprisonment, or both.
Okay. So that penalty clause for a conviction on section 34, subsection AB, is that the one you're reading? The penalty clause? Perhaps you can tell us where you are, sir.
Oh,
then we are all
page 61
of.
D2.
Okay.
Penalties section 49.
Yes.
and I can read it.
Yes, sir. We are waiting for your answer.
Yes. Section 49, a person convicted of an offense under any provision of this chapter is liable to a fine not exceeding 500,000 Namibian dollars or to imprisonment for a term not exceeding 25 years,
Okay.
or both such fine and such imprisonment.
Okay, and that's the reason why you're saying, particularly my client is likely to abscond because if he is found guilty, a competent court might impose a sentence of 500,000 or 25 years imprisonment or both.
That's not the only reason, because 61, it's a charge of fraud as well.
We will get there, sir. That's the next one.
Yes.
Okay.
Yes, on this specific charge.
Yes, that's where we are.
That's, yes, that's the reason.
Okay. Now, then we go to the subsequent charge. That would be charge 61, count 61 of fraud. What is the likely punishment my client would get if it's not gazetted?
Well, I know that if a sentence is more than 5 years, it would not be in the lower court. So in this matter, that would be determined by the court. That if he's found guilty, the court determining, or rather finding the person guilty, is the one which would determine as to how much that person would be sentenced, and it will be a discretion of that specific court if it's a high court.
Good. So you and I do not know at this stage what the likely sentence might be if my client is convicted of charge 61. Is that correct?
Correct. Okay. But it's serious in nature because it can attract direct imprisonment as well.
Okay. The next exercise we have to conduct is to deal with this issue of your strong case against Mr. Nandaro. That means we have to look firstly at the charges. Let's start with 60. And Mr. Inambao, before you say it, I'm not saying you drafted these charges. So we can leave that answer out. You can leave that out. I'm not saying it's your responsibility to draft these charges, but these are the charges we have today. If you look at charge 60, charge 60 says that Mr. Nandaro, on the 17th day of December 2022, the accused person corruptly paid a gratification. The accused person, not his CC, not the CC, you say he was 100% member holder. Is that correct? Is that what the charge says?
I thought you were still reading the charge.
No, I'm stopping there. Up to where I've read now.
Okay.
Is that what it says? That the accused person paid a gratification?
Yes.
Okay. And then it goes further to say that that gratification is 500,000 Namibia dollars that the accused person paid. Is that what the charge says, sir?
Yes.
And that this accused person paid the $500 gratification into the bank account of Quality Meat Supplies. And
$500.
500,000 Namibia dollars. Thank you, Your Worship. Into the bank account of Quality Meat Supplies. Is that correct, sir? Is that what the charge says?
That's correct.
Okay. The way I understand your evidence is that the 500,000 that is the subject matter of this charge was not paid by Mr. Nandaro or from his bank account. That's how I understood your evidence. Am I correct?
The 500,000 was paid from Erongos Petroleum's account into Quality Meat Supplies, and subsequent to that, it was paid into Quality Meat Supplies, and then from there, it went into the account of Panduleni family.
Yes. Now, so your answer is, I am correct. Your evidence is that it was not Mr. Nandaro who paid the amount himself from his own bank account.
Erongo Petroleum CC was at the time 100% owned by Mr. Nanda.
Okay, let's deal with that since you want to deal with that as well. May you please give him. Thank you. Your Worship, may I invite you to have regard to Exhibit G in these proceedings. That would be the notice of motion and affidavit in support of the bail application of Mr. Nandao. Okay. Mr. Inambao, my client in his affidavit makes the following allegation, which is directly at odds with what you are stating right now. He says that according to the documents provided by the state,
what page?
paragraph 43, I'm so sorry, my lord. 43 of the affidavit, paragraph 43.
So, are you there?
I'm there, Your Worship.
Okay.
We can proceed.
Okay. According to the documents or those documents provided by the state, Saima Emmanuel ceased to be a member of Erongo Petroleum on 23 November 2020, whilst Matthews Pandukeni Iambo and Christina Kambodi Ndafenongo ceased to be members only in 27 October 2023. That is according to the documents that were disclosed by the state. And these documents are in your possession, sir?
Your Worship, if the documents are there, we can still review them. But as far as my memory serves me, there was an amendment that was undertaken on the CC documents or the founding statements, May 2022. And then from there, where Mr. Nandaho became 100% owner, until sometimes in 2023, when the ownership changed, then Mr. Austin Elindi became a 75%, and then Mr. Nandaho became a 25%.
Mr. Inambao, this affidavit was filed a while back, and this specific allegations is made based on the documents in your docket, but you came to this court and you persist with your testimony even 2 minutes ago that Mr. Inambao was Mr. Nandaho is the only member at that period in time, 100%. Why do you do that, sir? I just want to understand. Is it an oversight, sir?
I just gave the response, and that is why I requested for the documentation so that we can, indicate as to what my response, why I responded as such.
I want to understand your answer, sir, and I need to be fair to you because when I make that argument, you won't be here. This document.
So I understand. You have put a question, and according to his response, is that there was an amendment sometime in May 2022 where your client or applicant number 7 became 100% owner until 2023. So I am listening. That question is there. You are repeating the same which he has just answered. Unless
I was not repeating, but I'll rephrase for the court to be on the same page as me.
Okay.
Let's have the dates correct, Your Worship. Let's take a step back, Your Worship. If you look at Exhibit D1, page 27, count 61, my Lord.
Which page under D1?
Do you need a flag? It's 27.
Yes, page 27. Come to 61.
Oh, it's this one.
Yes. Your Worship, if you look at that count, the period is December 2022 to May 2023, my Lord. And then, Your Worship, sorry, Mr. Inambao testifies about a time in 2020 when Mr. Nandaro allegedly became 100% owner.
Not 2020. He never said 2020. He said there was an amendment in May 2022 where applicant number 7 became 100% owner until in 2023 when Austin became 7% owner and applicant number 7 became 25%. Just the year that you said 2020.
Thank you, Your Worship.
Yes.
Yeah. The witness says Mr. Nandaro became 100% owner in 2022. Then Mr. Nandaro, applicant number 7, takes the affidavit, sets out exactly who was the member at beginning, when was it changed, based purely on the documents provided from the investigator's docket. So if you have regard to Annexure LSN 5, I'm so sorry that it's not paginated. I can quickly find it for you. Annexure LSN 5.
It appears, just cancel it. It appears you are moving because before I stopped you, you started count 61, period December 20
Yes.
to 2020.
And that is to deal with this specific issue, to point to the document where the people cease to be members. Your Worship, it's still the same issue, as it pleases the court.
Which document now?
Okay. Yes, I was tendering an apology that it's Exhibit G, applicant 7's application.
Yeah.
It's not paginated, but if you look at Annexure LSN 5, that is the one after the training authority statements of the plumbing qualifications. Okay.
Yeah.
I can just assist the witness to locate it. It would be faster.
Are you there?
If I do it.
LSN 5.
LSN 5. LSN 5 is a founding statement. Are you there, sir?
I'm almost, yes, I'm there.
Okay. So that founding statement runs up to, it contains 8 pages. Then after that you have an amended founding statement. That one.
Just be slow. It's not numbered, so.
I'm sorry, Your Worship. Okay.
Yes.
That one has
Amended.
also, that one is for 17 November 2020. It has also 8 pages, and thereafter you will find ID copies of the members. Then you find another amended founding statement. That one is the...
Council, we are getting lost. Yes.
Oh, sorry, Your Worship. You just page through. Let me take it easy.
Sir,
Page
can
1.
you go to the ID?
Yes, I'm at the ID, Your Worship.
From the ID? Yes, Council, can we start from the ID? Then we go.
As it pleases the court. Okay. Let me go back to the ID. Okay. There's the ID of Ms. Ndafenongo. Your Worship, you page past that one, Mr. Inambao.
Yes,
You find an amended founding statement.
Yes.
That one, the BIPA stamp says 2022-14, and then the month is a bit unclear, né?
Yes.
Okay. Then you page to the page that's written 2 at the top. Next page is 3. Pass that as well. Then you will find the page 4. You also pass that. Then you will find an amended founding statement for
Sir, are you there?
I'm there, Your Worship.
for Erongo Petroleum. It has a page 2 with the notes, page 3 which says part C, page 4 part C again, page 5 part C again, 6, 7, 8.
Just now.
Then you go to page 8. Okay.
Sir, are you there?
I'm there, Your Worship.
Okay. Mr. Nambao, this document indicates that these two people only ceased to become members of the CC on 27 October 2023.
Your Worship, we saw this document during the investigations. I also want to bring to your attention, if we can just go backward from where we are to go to the beginning of this founding statement where the other one starts, which
Yes,
which the council had actually ignored before. I mean,
Which one?
where the page 8 where we were just now, Your Worship.
Okay.
If we can just go backward until the beginning of the document,
Yes, sir.
where it's written CC2.
Date stamp, sir?
This one is 20. It's still the same document, 27
Okay.
October 2023.
Yes.
So
27 October. Where are you?
it would be after the page 2. I mean, we were going in reverse. So from 8, we are supposed to now be at page 1. Just before. Okay, there's no ID in between here, Your Worship.
Yes, hold it. Council, I'm getting lost.
Or Your Worship, to make
We
it
were
easy.
at page 8 of that document. Dated 27 October 2023.
That's correct, Your Worship.
Yes.
If maybe I can call Your Worship's attention to the place where we found the ID of Ndafenongo. I think that will be a better direction from there. And I got this document from the council, Your Worship.
Excuse me?
I'm saying this document is the one you just gave me.
Oh,
Yes,
okay.
I got it from you.
All right.
Here we have the ID LSN1. Is that where you are?
This ID, Your Worship. This ID.
Can I assist? Okay.
The document.
And Ndafenongo, Christina Camelo.
Your Worship, it's the same founding statement where we were.
See the document.
I can assist the court.
Yes.
Yeah. Let me put that. Let me I apologize, my lord. I just need it. All right. paginate during the break. I'm indebted to the court, Your Worship. I'll paginate the pages during the break. But the witness is the one who wants to take us there.
Yes.
Yes, sir. So where are you taking us?
Your Worship, I testified that from May.
I want to see where you are.
It would be the
Your Worship, the second flag?
yes.
Second flag for you? For the court?
This would be an amended amended.
What is the date?
There's a stamp.
It's 2022-05-14. 14 May 20. Immediately after the ID. After that ID. Yes, that one.
And so the second date is the date 27 October 2023.
Your Worship, can we? It's the first flag. Okay, let's look at the first flag. Does your first flag say MSN 5?
Yes.
Okay, then Your Worship, the second flag should be just after the ID copy of Ndafenongo. Miss Ndafenongo. That's where the second flag should be. Here.
I don't have the ID copy. I have, before that one, I have a certificate of incorporation.
Your Worship, let me give it one more try to take you to the page that the witness wants to go to. Let me just do that. Yes, the second flag. Your Worship, it's the correct flag. However, yours doesn't have a ID copy, I think. CC2.
That is the original exit.
Yes, Your Worship, we'll fix it now that it's come to our attention. Yes, got it, Your Worship. The second blue flag, Your Worship, that's the document the witness wants you to see. It's 14 May 2022.
14 May 2022.
Yes, Your Worship. When the council was cross-examining me, they said Mr. Nandaho was not 100% owner, and we list in my evidence in chief, I testified that he was the 100% owner from May, Your Worship. And this founding statement, Your Worship, this amended founding statement, Your Worship, if you go to page 3 of that document, Your Worship, you would see that there was one member, and there is a stamp on the side, Your Worship, which is dated 10 May 2022. Mm-hmm. And that one member who holds 100% interest, Your Worship, is Mr. Nandaho.
Okay.
And Your Worship, that information was obtained from this record. We also, Your Worship, noted, as the council has pointed out, that there is another amendment that was made.
In October 2023?
Yes, in October 2023.
Yes. Where
again Mr. Nandaho is listed as a 100% member, but then on the members who had ceased to be members,
yes, it was
listed the other individuals. It's something that we have observed, yes, and we have requested for more information from BIPA as to why this is the case. But at least the initial document which I pointed out gave us the comfort that Mr. Nandaho, during that period from May 2022 through, because even in October 2023, through to November 2024, I believe, when the last amendment happened, he was all along at least 100% on ownership. And I hope I've answered the question.
Actually, you have not. But I'll allow the court to finish.
Yes, we can question.
Yeah, Mr. Inambao, on your own thesis, the only comfort you would have gotten is that he is a member, not that he is 100% member. I say so because of the following. If you are sitting with a document that says these are members, they ceased to be members in 2023, then you are sitting with another document that says he was 100%, the only comfort you would have is that he was a member, but you would be unsure that he was 100% member because of what is in your possession.
Your Worship, these documents were legally obtained from BIPA.
Yes.
And they are in our possession, part of evidence, indicating that amendment which happened on the 10th of May, Your Worship, 2022.
You also had in your possession the amendment of 2023 October. Is that correct?
Yes, where Mr. Nandaho is still listed as 100% owner.
Yes, he becomes 100%
Yes.
because they cease on that day. They go out, so he must become 100%. Sir?
Investigations is still ongoing, and these are part of the sub-processes that we still need to inquire upon. For example, why is this amendment, and as I'm saying, we requested this information from BIPA. Why is this the case?
Again, on that answer that you just gave, you still have to determine who was actually 100% owner. So you cannot with certainty say that it was Mr. Nandaho, just on your own version.
Your Worship, as I indicated, our evidence at this point is guided by this very document, an amended founding statement of 10 May 2022.
According to your investigations, Mr. Nandaho, Mr. Inambao, when did Ndafenango cease to be a member?
If there was an amendment which made Mr. Nandaho 100% owner of this entity on the 12th of May, technically that should have been the time that they ceased to be members, because that was a time when the founding, or when the amended founding statement was, when the founding statement was amended.
Okay, so according to you, we must ignore the October 2023 document from BIPA, but we must rely on the one of May 2020.
No, that's not what I'm saying.
So
and if evidence further prove otherwise, it means those other parties which are not listed on this one, they get into the position of Mr. Nandaho.
No,
well.
That's not what it means, sir.
So, as I was saying, we are guided by evidence, and this is the document which we looked at. We found this. We thought maybe, in fact, when we analyzed, we thought maybe the authority made a mistake. They didn't sign the paper. We don't know. And as I said, we still requested for that explanation.
Then, to complete these questions, sir, when did Mr. Matthews Pendukeni Iyambo cease to be a member of the CC, according to your investigations?
10 May, definitely.
Okay. So we should also ignore the document that from BIPA that says he ceased to be a member in October of 2023.
I'm not saying we should ignore it in totality. The document is there, and when we obtain records, we obtain them objectively. We don't change them. We go to the authority, we request the documentations as they gave them to us, and then later we analyze these documents to try to seek an understanding as to why. In fact, I believe BIPA would be one of the bodies that will come and provide evidence, and they will also have to come and provide evidence as to why this is the case.
Yeah, to clarify who was the actual members on which date, correct? To give that clarity, isn't it?
Well, as to why the date of 23 October is written, but we know the amendment. There's a document here showing the amendment happened on the 10th of May, 2020. He became the 100%.
At 23 November 2020.
2022.
sorry, sir, I'm moving on to a next question to complete. If you look at paragraph 37 of the founding affidavit, or the affidavit of Mr. Nandaro.
Counsel, before you proceed, if I can just maybe also bring your attention just to one small minor detail. You see, Your Worship, if you look at the document, the amendment of 10 May, on that very page where it's indicating that Mr. Nandaho is 100% the owner. If you look at the date signed by the witness, the Andreas Shitatuli Shirunga, it's indicated 12 May 2022. If you also go to the document which the council is the amendment for 27 October, if you look at that document, Your Worship, also, if you look at the date there of Andreas Shirunga, it's the same with the one, it corresponds with the one of 10 May 2022. So all I'm saying is, in terms of the investigation, this is the evidence that we gathered, and it was objectively gathered, and we have made sure that we provided it as such.
Okay. Are you ready to go to the page which I am?
Yes, ma'am.
Yes. Thank you.
Counsel, before you proceed, the court will take a 10-minute
Okay.
record.
It's a lot of things to read.
Okay, thank you. Thank you. La translation of this.
It's like that. You want to
Es muy fuerte.
10 years.